Now let us test the tech. Can you see me and can you hear me, Shaq?
Absolutely. I had a bet on with Natasha that you'll have change your background, but
so this is the library of the future, everyone. I thought, you know, so many people have got bookcases, but in the future there won't be any books, and for many of you that will be a great disappointment. But Shaq, thank you very much indeed for having me on here. Dean Black Laws, another attribute, another arrow in your quiver. But what a fantastic program you're putting together. And I'm here to talk for a few minutes about the future of justice, because all of this legal technology, to the extent that it relates to making law firms more efficient, making lawyers better able to serve their clients, I think is wonderful. It's exciting. But from my own personal point of view, it's ever so slightly pedestrian. It is the fax machine to the email. It is the ledger to the Excel spreadsheet. All of it is for nothing, though, if people don't use the law. And why wouldn't people use the law? Because they feel it's not for them. And if it's not for them, it's because they don't like the system, because they don't trust the system. And when people stop trusting the system, then I think we have a much bigger issue than whether contracts can be read by a computer. So what's the future of justice? Well, some people see it as a robotic judge. As you know, Saudi Arabia has given the first passport to a robot. Sophia is her name. She's now a citizen of the Kingdom of Saudi Arabia. And many people see that judges like Sophia will sit in oak-paneled courtrooms and dispense justice. I think that's off. But interestingly, very interestingly, it does seem from the research coming out of the US that AI-powered decision makers do a better job than human judges in certain situations. So we're in a world now where computers can interpret contracts faster and better than human lawyers. And now we're in a world where computers can determine judicial outcomes with greater certainty and accuracy than human judges. Now, this will come as no surprise, of course, because the role of a computer is to take a vast amount of data, more than any human could ever process, analyze it, break it down, look at trends, and then determine an outcome based on a new set of facts. So if that's what we expect of our judges, it's no surprise that computers are now doing a better job in some areas. But what does that mean? What does that mean for mercy? What does it mean for clemency? What does it mean for equity? These are really important elements to a justice system, at least in my view. Are there machine learning tools that can deliver mercy, justice, fairness, equity? Not yet. So if we accept that the justice system and the legal system as a whole, which comes to a zenith at the justice system, the interpretation and development of the law, if we exclude mercy and we only apply logic, is that what we want? Is that the future? I hope not. There's no question that courts need efficiency. There's no question. But I think that efficiency not at the expense of humanity. And we'll explore this in the course. But let's come on to efficiency. So before COVID, many courts could have done with a bit of efficiency. There's 100 million cases backlogged in Brazil. There's 29.2 million cases backlogged in India at the last count. And I'm not sure if they stopped counting at that point. But post-COVID, even the developed systems have acknowledged that for civil justice, that's between people, commercial, to some extent, family and the like. Civil justice, there is a huge backlog. We are going to face a major crunch. And if justice delayed is justice denied, we're going to see a lot of people denied justice. So efficiency is going to be a critical component of how technology can help people to get access to justice faster through the courts. And then another component of what we're going to talk about is, do people use the courts? You know, so many billions is invested in what they call improving the courts, digitizing the courts, and all of these things. Let's stand back a little bit. What percentage of people around the world, this was a study done by the Hague Institute for the Innovation of Law as part of the United Nations Sustainable Development Goal 16.3. Take a breath. But the research went to, I think, about 80,000 people around the world and said, you know, if you're kept awake at night with a legal problem, a legal pain that's keeping you awake at night, would you go to court? And the data's terrifying. 95% of people asked said they would not use the court system established to help them. 95%. Then the question was, would you go and see a lawyer? 84% of people said they wouldn't see a lawyer. They think the law, the lawyers, and the legal system is not for them. It's for rich people, it's for powerful people, it's for other people, but it's not for the people. And so we have this massive justice chasm where so often we look through our binoculars at the court system, or to some extent arbitration, which is much the same nowadays. But we look at that and we think that's where we should invest. And the reality is we're blind to the 95% of people who do not have access to justice worldwide. In fact, more people have access to the internet now than have access to justice around the world. So how can technology fill that gap? Well, what people asked when they were asked, well, what would you want from a court system if you were going to use it? They said, what we want is to know their rights. You know, have I got the law on my side, and to have a system that helps them settle. Bear that in mind. Not one person, as far as I know in the survey, said, can I have a system that helps me fight? Can I have a system that makes me take them down? Can I have a system that makes me win so that they can lose? No, people said, can I know if I've got a right, and can you help me resolve this problem? Isn't that interesting? Whilst the courts and arbitration are set up to fight, it's adversarial, actually what people wanted was help to settle. So how can technology come in to do that? And we'll explore both concepts like lawyer, L-A-W-Y-A, which allows people to assess whether they've got a right, a legal right. And we've seen examples of this elsewhere in the world as well. And we've got Resolve Disputes Online and other companies like that that are helping people to resolve their disputes as well. Modri is another one in the US for family disputes. So we are now starting to see technology helping people achieve what they want. What's my right? Can you help me solve it? And I'll finish here with the last question that we'll be exploring. The greatest innovation in this space to fill the justice chasm is from the private sector. That is, justice is being privatized. And the question I'd like to pose is that right? Do we think it's right that we're leaving 95% of people to get their justice through private sector tools, private sector apps? Or should this be something that the courts should be working on? Should the courts be looking to the 95%? Should the courts be introducing what the public wants, not what the court system wants? Should the courts be offering solutions and not the fight, not the problem? Should the courts be allowing people to get information about whether they have a right or not? I certainly am of the view that they should. Courts are a public service. Second word is service. But I think in many systems, it's been developed that it's actually the tail wagging the dog. If you want to go to court, you do what the court tells you. You file what the court tells you. You comply with what the court tells you. At no point will someone say, how can we help you? How can we help you? What do you want from this process? What would be best for you as a citizen, as a taxpayer, as a contributor to society? How can we as a court system help you? And that's not the way they're designed. Should they be redesigned? Should we break them apart like a good sort of tech platform, split them apart and put them back together better? Or do we allow the private sector to own the justice space? That is a taster for what we're going to discuss on the course. I hope you're going to find it interesting, and thank you very much for the opportunity.
Thanks, Mark. A couple of questions for you. One is around, just come in through the Q&A. One is, I think you've answered it, how will technology democratize the access to justice? and why it's important for legal practitioners to become aware of the new technologies and how the LTIC will address this. So I think we've covered that technically. The other one is
let's start there, Shaq, because that's a great question. I love this concept of democratization of justice. Okay, it's what we saw originally with people claim out of the US. This frustration that the system does not allow some form of consensus around decision making. I don't call it democratization because that limits it to some extent to jurisdictions that are democratic. The whole world needs consensual based decision making. There is wisdom in the crowd, and many of the tools that are coming in now, which gamify. So if you look at Alibaba, largest online retailer in the world, they've taken the PayPal dispute online platform to the next level. You can sign up to be as a customer on the Alibaba platform. It's, for those that don't know, it is a bit like Amazon for China. You sign up to become a judge and you put your views forward on whether a dispute should be upheld or not. And the majority of the judges, the majority decision of the judges is upheld and the system enforces. And the more often you're in the majority, the more often you're in the consensus of the tens of thousands of judges that decide on any particular dispute, the higher the ranking you go up as a judge. So the more often you get the common sense, correct, for the purposes of the community answer, an answer which is based entirely on consensus, then the better you do as a judge. Now, we've taken that one step further with rhubarb in the US, where you actually pay to be a judge. So you put your 50p or your 50 cents in to vote as a judge on a case. And if you're in the consensus, if you're in the majority of the decision, you share the whole pot. So people who are outliers in their decision making effectively fund a decent ROI, about 11 to 12% ROI on those that get the consensus. So we are starting to see now the gamification of justice. We're starting to see consensus-based justice. Question, is that right? Is it justice just because the crowd says it is? Is that what we want of our justice system? Or do we want to steer back towards having somebody with a wig and a gown and wearing dead animals? Should they be deciding what the right answer is? And I often say, if an alien came down from space and said, for the biggest businesses you've got in the world, the biggest drivers of employment, the biggest drivers of economic growth, if they fall out with each other, if Apple and Samsung fall out, tell me, what do you do to resolve? Because this is a systemic kind of issue. If two mega banks fall out and it's a systemic issue to the system, what do you do to resolve that dispute so that they can move forward? And our answer is, well, we spend sort of 5 or 6 years developing a whole load of paperwork, and ultimately it goes to generally an old man who's never been in business, doesn't know much about money. That's what clerks are for. Wasn't there when any of the discussions took place that have led to the dispute. Doesn't know the first thing about the banking system beyond what they've read as a judge. And we're going to ask them what the answer is. And then whatever the answer is, the state will enforce. I think the alien would go away thinking we've gone bonkers. So the traditional system has a critical place in our society. It has to be the last bastion. But is it the last bastion? Do we treat it that way? And if we do, what do we need to have in advance of it? So I love the question about democratization of justice. Question from my point of view, and one of the things we need to explore is that what we want from a justice system? Shaq, what was the second question?
Thanks, Mark. There was one, could you cite the source of some of your statistics in terms of why people don't want to take down their counterparts? My experience as both a litigator and mediator is just the opposite. People are willing to lose money to see the counterparts suffer a blow, and that's from Tallinn. Yeah.
Well, look, I no disrespect to any lawyer on the call, but lawyers generally tend to rev up their clients to want to have a fight. They talk about winning, they talk about victory, they talk about the battle, right? This is what lawyers do. I was one for many years. And when I moved to become general counsel for South Asia, Middle East and Africa for MasterCard, we started to have a different discussion, which is how do we build business? How do we use our problem as an opportunity to grow the portfolio? How do we use this access point in to grow more business? And that shifts you from being a dispute winning lawyer kind of lawyer, winning losing kind of lawyer. We're going to win this battle to hang on a second. We've reached an inflection point. Let's work out what the maximum opportunity is going forward. And that's a commercial perspective. That's the difference. when you have a conversation with a client and you say you have a claim for $100, but the net present value of your claim is $12 because it's going to take you 6 years to get an answer, it's likely to be only 80% enforceable. Your legal costs will be recoverable to 60% and you will lose the relationship. Therefore, the net present value of your claim goes from $100 to, pick a number, $12. And this is a calculation that's being done now by the litigation funders, by the commercial diplomacy firms, and it's exactly what the client wants. Tell me the value of my claim. When you start to talk to clients about a net present value that's 80 or 90% less than the number they have in their head, actually they don't want the fight anymore. What they want is settlement. But in terms of the statistics, I told you what it is that people want. Go to the Hague Institute for Innovation of Law, and I think the research report is Elephant in the Courtroom, because it talks to exactly these misconceptions. The misconception that people really want to end up in court, they really want to be in front of a judge, they really want to pay lawyers, they really want to get a decision. And particularly in cross-border, of course, most of them get a decision which is largely unenforceable. They get stuck. Lawyers will quote all of these conventions at you, but east of Suez, they're largely ineffective. So you end up with a client who, and I've been through this, I've been through this where the lawyer says, yes, we won the case, we won, it's fantastic, I'm such a good lawyer, we've won the case. And then you say, yeah, but where's the money? They say, well, yeah, that is the tricky thing about getting the money. Yeah, we don't do that though. You have to find an enforcement firm to do that. So I hear the question. It's a view quite often expressed. The data on the human side is the Hague Institute report. And I think more generally, it's the difference between a private practice lawyer and an in-house lawyer with such different perspectives.
Thanks, Mark. There's one more. Well, there's a couple. It's a popular topic. It is around smart courts. Whether we'll talk about smart courts in the module, and then just following on from that, there's one from Vanessa around contracts. Shouldn't lawyers rethink their practices? Shouldn't they be writing contracts to help business as opposed to simply making them watertight when presented in court?
Vanessa, I love that question. And actually, there's a great piece of research which you can find now, which talks to CFOs and CEOs about their own legal team. And the overwhelming feedback is, I don't include them in anything because they're a complete pain. And there is this sense, that lawyers keep talking about belt and braces, which I think is an extraordinary phrase. But what it means is they're not doing their job, because their job is to assess risk. Having had positions that are outside of the law, I can tell you for certain what I'm looking for in advice is, what's the upside, what's the downside? Assess the risk for me. I'll make a decision based on that. Don't just tell me it can't be done. Don't give me a 100-page document that says much the same thing. And there was a guy called Chris Rawstron, who was a partner in the first firm I worked in, first law firm. And he had a broad northern accent. He was from Yorkshire. And he said, Mark, you can do more damage in a sentence than you can in a chapter. And it always reminded me, I said to him at the time, what do you mean? And he said, actually, when you're drafting, the inclination of many lawyers is to have the chapter. But if you really want to cut through and you want to have power in your contract, make it a sentence. And I'll finish with this, Vanessa, which is where we're moving towards now. Two elements. One is drawn contracts are proving to be much more effective than written contracts, particularly cross-border. So if you look at the work Shell's done, and that the World Contract WC, World Commerce and Contracting Association, there's a lot of work about pictorial contracts, and that's proving to lead to much less disputes than written contracts, because people can see what they're meant to do. And the last point on this is, as we move to smart contracts, there won't be anything written, there won't be a quill anymore. It's going to be coded, and you're going to plug into that coded contract. So law firms at the moment probably are not well versed in drafting and analyzing smart contracts. That needs to change too. And when we move into a blockchain-based smart contract environment, we improve efficiency of the contracting process enormously. We do away with privity, so we don't have all the nonsense around somebody 12 down the layers and the chain goes bust and the whole thing falls down. People can get paid immediately, and the owner at the top of the contract has complete line of sight on their supply chain. It's the future of contracting. 50% of all international contracts will move to a smart contract environment within 10 years. That's my prediction. So then you're absolutely right. Then lawyers have to again rethink what service they're offering. It's not about drafting long paragraphs. It's about plugging the right elements into a smart contract environment that provides a uniform and risk-adjusted basis and allows the contract to run itself, doesn't need lawyers or contracting people to be constantly looking over it. So the future on the contracting side is hugely exciting. And then the question is, are there any courts or arbitration centers that are currently able to, one, determine smart contract disputes, and two, enforce their decision into a blockchain-based smart contract operating on 1,000 nodes across 50 jurisdictions? Is there a single court or arbitration center with authority to recode a decentralized smart contract sitting in 50 jurisdictions on 1,000 nodes? And the answer to that, obviously, absolutely not yet.
Thanks, Mark.